Judicial Independence Podcast. Podcast on the challenges to the independence of the judiciary, access to justice and the protection of human rights across the European Union. Welcome to this podcast mini-series on the judicial independence in the EU. This podcast is part of the Rule of Law for Lawyers project, led by the International Commission of Jurists in partnership with Free Courts, Aditus, Forum for Human Rights and Human Rights in Practice, looking into the current challenges to the rule of law, especially to the independence of the judiciary in Europe. These challenges are numerous and in many cases extremely serious and can limit access to justice and have negative impacts on lives of millions of people across the EU. In the 10 episodes of this podcast, we will speak with experts and legal practitioners to shed light at some of these issues and will discuss about ways to protect and preserve judicial independence so that human rights across the EU can be effectively protected. Welcome to all listeners to this podcast mini-series on the rule of law in the EU. I'm Karolína Babická, legal advisor with the ICJ, and our first guest today is Róisín Pillay, the director of the ICJ's Europe and Central Asia program, with whom we work together on this new project. So, Róisín, welcome. Welcome to this podcast. It's a pleasure to have you as our first guest.
Thank you, Karolína. Very happy to be here and to have this discussion.
You have really years of experience working on the rule of law in Europe and Central Asia, and you are probably one of the best persons to explain in the beginning why is it important that we speak about the rule of law and why is it problematic when it gets under threat.
Well, thanks. I mean, I'm not sure that I'm the best person to explain, but I've certainly been working on this for many years. Mm-hmm. And I think through this podcast, we'll hear from other people, and especially people working at national level, I think, which are, they're also the people that can really tell us what it's like to try to challenge abuses of rule of law and try to reestablish rule of law where it's been eroded. I think in Europe, I think the rule of law is something we didn't think about very much as a national issue, as a domestic issue for our countries for a long time. And I think it's partly because it's a very abstract concept, especially when, it seems to be fine in your country. The rule of law is something that everyone pays lip service to. Everyone says, of course, rule of law is really important and it's a great part of our tradition and our legal system and our constitution. But I think we, to a certain extent, became complacent that, of course, these principles were very important and were upheld in our systems because we have these really long historical traditions of rule of law. But then, we have to think, what does rule of law actually mean to see if we are really upholding it in practice. And now, of course, with the real threats and the real erosion of rule of law in a number of European countries, we've had to really confront this. And the rule of law, what this kind of abstract principle means, is actually something very practical. And you see that immediately once you don't have it anymore. So really what it means is that the law has to be there, has to be not just there on the statute books, but actually applied effectively and applied in a way that protects people, that protects people's rights, and that it's fair, that it's effective in practice, so people get remedies, so people get accountability where they've suffered damage. And of course, in order to have this thing that we kind of take for granted in many countries, in order to have it, you have to have institutions in place that prevent abuses of power and that hold the powerful elements in the society to account. And that's, of course, first amongst those institutions is the judiciary. You have to have an independent judiciary. and you have to have an accountable judiciary, an uncorrupt judiciary. You have to have separation of powers so that there's checks and balances on power. And you have to have other institutions like a free media, like a free civil society that can also hold power to account. So all of those elements are the kind of the real meat of the rule of law. And there's very real consequences where they're removed. And, we see that in states outside of Europe. And now we see it also in states even within the European Union, where those conditions, those institutions are weakened or eroded or just removed. Then it's very easy to violate people's rights. It's very easy to manipulate the law in corrupt ways for the interests of your own interests, your friends' interests that you have for political purposes. So you have deep corruption, you have violation of rights, you have discrimination, and those are really significant abuses of power that really affect everyone's lives. And so that's the real importance of rule of law.
Mm-hmm. Yeah, thank you so much for this overview, and I agree that basically we got used to the idea that really the rule of law is there for at least in the European Union, and of course we probably have not been so prepared to deal with such erosion of the basic institutions, and especially the independent judiciary at the EU level. We have been hearing in the past years about the rule of law crisis in the EU, and actually we also at the ICJ have been following this quite closely. We have intervened in some of the cases in front of the European Court for Human Rights, for instance. We engaged in some advocacy towards the EU institutions. So could you please say a bit more about that work and about the whole crisis overall? What has it caused, and where are we now?
Well, of course, as everybody knows, I mean, we saw in the last years a move towards authoritarianism, really, in a couple of EU member states, I mean, most notably in Poland and in Hungary, and of course, that reflected a wider global trend. I mean, a terrible rule of law crisis, for example, on the borders of the EU in Turkey, but also deterioration, in Russia, in a number of countries in the region and beyond, also in the MENA region. But so we saw this move towards authoritarianism, and what authoritarian regimes do is they try to remove the checks on power. And it's interesting that the kind of playbook is in many countries is quite similar. I mean, first of all, some of the first things to be attacked by authoritarian governments are the institutions of the judiciary, the higher courts, the Constitutional Court, the Supreme Court, the security of tenure of those judges, the appointment process for those judges. And in this way, they try to remove these checks on power. And then later on, you see civil society being under attack. You see the media, you see lawyers, and so there's a gradual elimination of all of the barriers to the exercise of power. So we've seen this happen, and so I guess it's something you'll talk about more in other parts of the podcast, how that specifically happened in specific countries. And then, of course, you get to a point, and it happens quite quickly. And this is the shocking thing: is how quickly this can come apart. You get to a point where it's very difficult to get effective remedies anymore at the national level, because the courts have been captured, or certain of the courts have been captured. And so then you have to look at how the international mechanisms can respond, because we have these, at EU level, we have mechanisms to enforce fundamental rights that use fundamental values, including rule of law, democracy, and fundamental rights. And then internationally, at Council of Europe level, at UN level, we have these international human rights law mechanisms, and they are there exactly to act, to be used where where the national systems have failed. And so what ICJ and other NGOs, I guess international NGOs mainly, have been trying to do, working with the national NGOs, is to use these mechanisms, or to support them being applied effectively. And of course, it's been the national civil society that's been really the most important. They're the national lawyers. I mean, they're the ones who brought the cases to the European Court of Human Rights, for example. And ICJ has been intervening as a third party in those cases, and sometimes along with other NGOs, and really just to describe the international law and standards that apply, and sometimes the national situation, and to try to ensure strong decisions in those cases. And we've got some very strong decisions in some of those cases, which has been really helpful. And then there's been also an NGO effort, a joint NGO effort, really amongst human rights organisations, to advocate at EU level, to make sure that both the legal processes and the political processes at EU level react appropriately and strongly to this deterioration in the rule of law, because it's really important. This is also a test of these international systems. They're here for exactly this kind of crisis, these European systems and global ones, and so we can't afford for them to fail, actually, in these circumstances, because that undermines their credibility and their effectiveness for other similar situations that might arise in the future.
Yeah. Thanks so much. Indeed, and one of the mechanisms that we have at the EU level is the Article 7 procedure, which is basically there to somehow protect us from the erosion of the rule of law and from the erosion of the fundamental values of the EU that all the member states should normally adhere to, based on the Article 2 of the Treaty of the European Union. Can you explain a bit more about the Article 7 procedure, and why does it seem a bit complicated for the EU to move forward with this?
Yeah, I mean, I suppose it's fundamentally complicated because it's a political procedure, and therefore it's subject to all of the different pressures that the political procedures are always subject to. But it's also a very significant procedure, because it can lead to the suspension of voting rights, for example, of the country concerned. And it's really designed for the most serious cases of the violation of the fundamental values of the EU, of rule of law, fundamental rights, and democracy. And it has been invoked, this process, both in relation to Poland in 2017, the Commission, and Hungary in 2018 by the European Parliament. But then to move forward with this process of sort of sanctioning these countries for violation of these fundamental values, you need a vote of the member states, and this is really difficult to get in the Council, and so this is going to really be a challenge to have the guardians here of the rule of law are the member states themselves, and there are other political considerations that arise, and so these processes have been really slow to progress. There've been some discussions, but it's really very slow. So that's where we are. That those processes have been initiated but have kind of stalled, and it's quite difficult to see really how that could at this stage. it's difficult to see that having a very big impact. And then, of course, there's other political processes going on related to the use of EU funds, which have helped to put some pressure on the member states at a political level. But again, they're subject to negotiation and so on. And so then, and then we're left with the legal processes, and the Commission has been quite strong in bringing infringement proceedings, for example, against in both Poland and Hungary, and we've had good judgments from the Court of Justice of the EU, and then of course the European Court of Human Rights at the Council of Europe level. And again, we've had some really strong judgments. Now, those legal processes then really have challenges as well, because then you get to the implementation phase, and then that's always where the challenge is, to actually make sure those judgments are implemented.
Yeah, exactly. Thank you so much for bringing this in as well, like the role of the courts and strategic litigation overall, and of course the challenges related to it, with decisions in the end being or not being complied with by the member states. So perhaps finally, as also our project is going to focus quite a bit on strategic litigation, can you say a bit more of what we're planning to do within the next 2 years, with what we are trying to achieve with the Rule of Law for Lawyers project?
Yes, so this is a new project that we're starting, and it's also kind of a continuation of our work that ICJ has been doing, and of course that the other partner organizations have been doing for a number of years. And in this project, we're trying to support lawyers throughout the EU, but in particular in countries where the rule of law is under some threat, where there are problems of judicial independence, judicial accountability in particular. And we're trying to support lawyers to address that through using the law, using national law and international standards we have relation to rule of law. Because these are all tools that we have in our hands to try to address these issues. And, it's better to address them at the earliest stage possible before we reach the absolute breakdown of the rule of law. So we want to really use the experience that we have, that lawyers, especially national lawyers in some EU countries already have in bringing cases on these kind of issues. That international organizations like ICJ have. ICJ has been working for decades to address problems of judicial independence, not only in Europe, but around the world in some really challenging countries. And some of the partners in this project have really interesting experience in litigation on these issues. So we want to try and bring this all together and exchange these experiences in quite a practical way, so that lawyers are really equipped to address these issues that are already there, or when they arise, that we can use strategic litigation, that we can also advocate and speak out in our countries in the EU about these problems. And I think in the background of this is that what ICJ has always believed, that lawyers have a particular role and a responsibility to uphold the rule of law, because these tools that we have of international law and standards, lawyers in particular are kind of guardians of those. And so we're trying to help lawyers and to connect so that we cooperate with lawyers also in making these tools and these systems that we have effective. And Karolína, maybe you can say more. Also, we have, maybe I'm being a bit too general, but we have some, of course, specific activities that we're going to do. We're going to do workshops where we bring people from different countries to share experiences, to discuss quite specifically, the problems that they face, the challenges, what has worked, what hasn't worked, to also inform people about developments in international standards and jurisprudence. And so we're going to have quite a lot of events and workshops and discussions throughout this project. But I mean, yeah, you're going to be very, very involved in this, so you can say even more than I can.
Yeah, no, but thank you so much for this. Indeed, we're really looking forward to starting this project fully. Maybe I can just add that we will definitely have some of these legal experts, as you mentioned, that we will be working with throughout the project, also as guests on this podcast. So really a lot to look forward to. So, yeah, Róisín, thank you so much for joining me today in the Rule of Law in the EU podcast. It was a pleasure talking to you.
Very nice to talk to you, and thanks. And I'm very, very proud to be the first guest, but I'm sure there'll be much more interesting ones in the next podcast. So I'll be listening in.
Perfect. Thanks a lot. So thank you also to all the listeners for tuning in today and looking forward to the upcoming podcasts. Goodbye.
Thank you.
Thank you for listening to the Judicial Independence Podcast.